Darrell Brooks is now getting his turn in the Waukesha parade attack trial, the state resting its case today.
Joining us tonight to discuss today's developments, attorney Craig Mastantuono from the Mastantuono Coffey and Thomas Law Firm. Craig, we want to start with the opening statement, a clip from his opening statement from Darrell Brooks.
The fact is, this incident was tragic, very tragic. That's not lost on me, but I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional. And this incident was never even thought about.
He had deferred his opening statement, so that's why he was giving it today. So what did that opening statement tell you about the strategy for his defense?
Yeah, I watched the whole thing in its entirety, and after that moment, that was in the first couple of minutes where he said this wasn't intentional or not planned, I was waiting for, a theme then to be developed by him about how he was the actor perhaps and didn't act intentionally, as if this was some type of accident or reckless conduct. But he didn't really go there. After there, he didn't lay out why he's not guilty or guilty of a lesser offense. He simply asked the jury to, pay attention to other factors and what the other side of the coin was. I wrote in my notes, well, what is that other side? We're waiting for the theory to be developed. On opening statement, you always come out and let the jury know right away, this is why my client is not guilty, or this is why my client's not guilty of what he's charged with.
And after the opening statement too, he talked about his first witness, called his first witness to the stand. Obviously, very tense moments with that first witness, a friend of his ex-girlfriend who he's accused of hitting on the day of the trial. What is it going to hurt him at all that he hasn't called a witness that's on his side?
Well, look, generally, right, we always want to call witnesses that we believe will provide favorable information to our case. And so it's not the best look when you call a witness and then you're arguing with that witness. There is a time, it's very limited in trials for calling an adverse witness, but it's really not where you want to be as an advocate when you're arguing with your own witnesses.
And we heard what Hillary was reporting at the top of this newscast about a possible counter to the plea deal. Is something like that still possible at this point? I mean, could there be a plea deal this late?
I've resolved cases while the jury is deliberating, big ones, and during the time right up prior to trial and during trial. So yes is the answer to your question. Do I think that's likely in this case, that DA Opper is waiting for Mr. Brooks's counteroffer to consider it? Probably not. It's possible, but I don't see how a settlement could be possible in this case, unless Mr. Brooks decides to enter a plea to just about everything, would be the state's request. I think, though, even at this point, they may just say, look, we've presented our case. We're presenting it to the jury and letting the jury decide the case now that we've had to go this far.
And we heard his opening statement today, Darrell Brooks, because he deferred it. What do you think of that decision to defer it?
It's generally not a strategy favored by defense attorneys because the state puts their theory of the case in during the opening statement. It's the first thing that happens after jury selection, right? And so the defense wants to get right there with the prosecution and say, no, here's why the defendant is not guilty in this case. So I rarely see a colleague defer opening statement until the end of the state's case.
All right, Craig, thank you very much. And again, we are streaming every moment of the trial. We'll have it on WISN.com, the 12 News app, and the 12 News Facebook page.